Hi guys, welcome to the webinar Ethics, Conflict of Interest, and the Unauthorized Practice of Law. Super exciting materials to go over. I will try not to bore you and get to the material. My name is Jessica Metry. I am an attorney licensed in Minnesota and North Dakota. I've been affiliated with the Estate Planning Source for probably a little bit over 3 years now. This slideshow might look a little familiar. I did present it at the Advanced Institute back in 2022. So just going through this, we're just going to go over the conflict of interest. This is going to be mostly in terms of like attorney-client, not in a financial advisor aspect. And then we're going to go over the unlawful practice of law, and this kind of is tailored more towards financial advisors. And then kind of how the estate planning source model plays into all of that and practices that we can, as attorneys and financial advisors, can put in place to just make sure we got good practices and mechanisms. So first topic is conflicts of interest in estate planning. So the main thing that attorneys use to figure out if you do have a conflict of interest is we look at the rules of professional conduct, and it helps to know kind of what exactly is a conflict of interest. According to the legal dictionary, a conflict of interest is a situation in which a person has a duty to more than one person or organization, but cannot do justice to the actual or potential adverse interests of both parties. In the context of an attorney-client relationship, we'd want to look at Rule 1.7. That's pertinent for current clients. There are a few other rules that we'll kind of take a peek at. Rule 1.7 is here. This is kind of a lot in a mouth drop, but this would be your main rule that one would look at. 1.7a says you shall not represent a client if the representation involves a concurrent conflict of interest. So what exactly is a concurrent conflict of interest? So a current conflict of interest exists if representation of one client will be directly adverse to another client, or there's a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibility to another client. It could be a former client or a third person, or personal interest of even yourself, the lawyer. So this doesn't just apply to current clients. This applies to former clients and also third parties. So you do have a duty to your former clients, even if your representation with them has ended. So just keep that in mind, because sometimes that's easy to forget. 1.7b, notwithstanding the existence of a concurrent conflict of interest, you as a lawyer may represent a client if 1 through 4 here are met. So you must reasonably believe that you'll be able to provide competent and diligent representation to each affected client. It's not prohibited by law, and the representation does not involve the assertion of a claim by one client against another client represented by the lawyer in the same litigation or other proceeding before a tribunal. And lastly, each affected client must give informed consent, and it must be confirmed in writing. So conflicts of interest can arise in even the most innocent of situations. They're usually never intended. So the best strategy for avoiding them is for attorneys to advise clients and potential clients regarding how and in what situations conflicts may arise, be anticipated, and in some instances, decline representation and play it safe. Conflicts in estate planning. So usually estate planning is pretty non-adversarial. When giving estate planning advice, an attorney must adhere to the requirements that are required by the rules of professional conduct. Must provide zealous representation, competence, loyal, and confidentiality. According to the American College of Trust and Estate Counsel, Estate planning is fundamentally not adversarial, like I said, in nature, and estate administration is usually not adversarial. But that doesn't mean that conflicts can arise. I would say conflicts can arise when you have a duty to a former estate planning client, things like that to keep in mind. So maybe during the process there's not a conflict, but a conflict can arise later on. It's kind of what we look for. So one of the biggest things that we want to make sure is clear to avoid conflicts of interest is, who do you represent? So absent a written agreement to the contrary, joint representation is usually assumed. A major consideration to take in when deciding to represent two members of one family is your duty as a lawyer of confidentiality. Rule 1.6, confidentiality of information, provides the lawyer must not reveal information relating to the representation. For example, one spouse may provide confidential information that is not intended for the other spouse. That can kind of create a sticky situation for you as the attorney. So if it was joint representation, you should disclose that confidential information, obviously. And then if it was separate representation, you as the attorney cannot ethically disclose that confidential information that was provided to you to the other party. Typical estate planning scenarios. So the most common situation is the attorney represents the husband and wife. Spouses come into your office or workshop and seek help implementing an estate plan. Usually their wishes are the same. They want to transfer their assets to their children, identical charities, etc. So there's not really an actual conflict there. There's no real significant risk that representation will be materially limited by your responsibility to the other spouse, just because usually the wishes align. Arguably, attempting to represent a husband and wife separately while simultaneously doing estate planning for each is generally inconsistent with the lawyer's duty of loyalty to each client. Either you should represent them jointly or the lawyer should represent only one of them. And if there is a risk, the attorney must get consent from both clients for dual representation and believe they'll be able to give competent and diligent representation. So I always like to say, even if you do get consent from both clients in writing, as the attorney, you do still have to believe that you can give competent and diligent representation in those situations. Let's look at some examples here. So this one, we have a married couple hire an attorney to create wills for them. Husband reads his will, signs it, and leaves without reading his wife's will, but assumes they are reciprocal. The attorney then prepares a deed transferring the husband's residence to his wife to equalize their estates. However, wife leaves most of her estate to her nieces. So that's what her will reads. Is there a conflict of interest? The answer is yes. Once the attorney was asked to prepare a deed transferring property to the wife, conflict existed. This is because when the husband asked the attorney to prepare a deed transferring this house to his wife, and the attorney knew that at the wife's death, the house would pass to her nieces and not the husband, he should have disclosed the relevant information or withdrawn his counsel. This information was pertinent to the common representation of the parties, and the lawyer has an equal duty of loyalty to each client, and each client has the right to be informed of anything that might affect the client's interest. Example number 2, you are working with children of married clients after both parents have died. You're guiding them through the practical legal advice to properly administer an estate. One child is appointed trustee. Some of the children are resentful as they received unequal shares. Conflict of interest if you represent the trustee of the trust and the beneficiaries of the trust. So in this case, a child is appointed the trustee, and then there's multiple children as the beneficiaries. The answer is yes, there's a conflict to represent more than one party. Their interest could be adverse. There could be different duties owed to the trustee and the beneficiaries. However, may the attorney just represent the child trustee? So you originally, your former clients were the parents, and now one of the childs come into your office and they're appointed as trustee and want to hire you to help them administer the estate. Is there a conflict of interest between that child trustee and your former clients, the parents? The answer is there's not a conflict, so you could represent the trustee in this case. Example 3, a husband and wife hire an attorney to create a trust for them. The trust will benefit the other spouse during the survivor's life, and they inform the attorney about both passing, and they want the estate to pass to their joint children. So after the spouse is passed, their primary beneficiaries are their joint children. However, upon the passing of the husband, the wife comes in and says she's the current beneficiary of the trust and wants to set up a new estate plan, put her new husband and non-joint children as the new beneficiaries. So essentially disinheriting all her joint children with her former husband. Is there a conflict for the attorney to draft these legal documents? The answer is yes. He has a duty to his former client. So if I was in this scenario, which I hear can happen a lot, I haven't personally had to do this yet, but I would just decline representation, and not even just based off a conflict of interest for me, but also just ethically, I don't know if I would be able to do that, even though it is her prerogative and her wishes, but I would probably refer that one out. Example 4, husband and wife retain you to create a joint revocable living trust. You are working on funding the trust, and later the wife comes to you and states, I have this other account that my husband does not know about. Can you set it up so the funds go to my boyfriend? And by the way, don't tell my husband. Is there a conflict? Yes, there is. You have a duty to inform the spouse of the information because it's pertinent to the representation, or you could simply withdraw as counsel. So some best practices to have in place. The first one is your representation. Make sure it's clear who you are representing, because if it's not clear, then it's hard to distinguish if a conflict of interest has arisen, or if you owe a duty to a former client. Conflict. So every time someone walks in your door, evaluate whether there's a conflict of interest before you begin the representation. And then having a good waiver in place. So if a conflict does exist, evaluate whether it can be waived. Make sure you fully disclose it and have a written agreement in place. Setting expectations is a big one. So at the outset of common representation, and as part of the process of obtaining each client's informed consent, advise each client that information will be shared, that the lawyer will have to withdraw if one client decides that some matter material to the representation should be kept from the other. Make sure they fully understand the confidentiality that would be maintained with respect to communications made by each party in joint representation. And at the outset, discuss estate planning goals and terms which you will represent the client. Lastly, have an engagement letter in place that clearly defines the client being represented, the scope of work that you're conducting, disclose any conflicts if there is any, and in joint representation cases, including in your agreement that you may share any information disclosed by one of them with the other is a good practice to have in place. Some rules in mind for attorneys to keep in the back of their brains are the fund rules 1.6, 7, 8, and 9. Conflict of interest to current clients, duties to former clients, specific rules for current clients and conflict of interest, and then obviously confidentiality information is a good one to always refer back to. In summary, if prospective clients have common estate planning objectives and coordination is important to them, and there does not appear to be any prohibitive conflicts, the best practice would be for you as the lawyer to undertake the representation of the two clients jointly with an agreement that information can be shared between you guys. If there is a risk of a conflict, the attorney must get consent from both clients for dual representation and believe they will be able to give competent and diligent representation. Next topic that we're going to talk about is the unlawful practice of law. Most of the information here I got from Rule 5.5, Unauthorized Practice of Law, under the Rules of Professional Conduct and Multi-Jurisdictional Practices of Law. So let's define what the practice of law is so that we can understand if we are even doing it. So according to the ABA, American Bar Association, the practice of law shall be performed only by those authorized by the highest court of this jurisdiction. They define the practice of law as application of legal principles and judgment with regard to the circumstances or objectives of a person that require the knowledge and skill of a person trained in the law. A person can include plural, singular, can be a commercial entity, etc. Here, a person is presumed to be practicing law when engaging in any of the following conduct on behalf of another. So, giving advice or counsel to persons as to their legal rights or responsibilities or to those of others. I feel like that one's pretty easy to do. So that one I would always keep in the back of my mind. Selecting, drafting, or completing legal documents or agreements that affect the legal rights of a person. That one's kind of obvious, although I still am confused on how some realtors can draft deeds, because that is a legal document affecting their rights, but they still do it. 3, representing a person before an adjudicative body, including but not limited to preparing or filing documents or conducting discovery. 4, negotiating legal rights or responsibilities on behalf of a person. Expectations and exclusions, whether or not they constitute the practice of law. These are 4 things that are permitted. So practicing law unauthorized by a limited license to practice, pro se representation, serving as a mediator, arbitrator, conciliator, facilitator, and providing services under the supervision of a lawyer in compliance with the rules of professional conduct. E here says that any person engaged in the practice of law shall be held to the same standard of care and duty of loyalty to the client, independent of whether the person is authorized to practice law in this jurisdiction. With regard to the exceptions and exclusions listed above in D, if the person providing services is a non-lawyer, the person shall disclose that fact in writing. If a person who is not authorized to practice law is engaged in the practice of law, that person shall be subject to civil and criminal penalties of the jurisdiction that they're licensed in. So what that looks like today, obviously law is becoming more commercialized and sensitive to supply and demand. You have LegalZoom, Law Depot, just a few off the top of my head that pop up all the time. And then you also have realtors that draft deeds, etc., those types of things. So commercialization doesn't have to affect the quality of the estate planning services that us as attorneys provide. If anything, in my mind, the quality that we give is a lot better and more cumbersome than those things, those websites out there. Keep in mind that only licensed attorneys can provide legal services, and us advisors and attorneys can work together to efficiently and less expensively provide estate planning services to our clients. Looking over some general strengths and weaknesses of estate planning attorneys and kind of how they may intertwine and play with how financial advisors and us as attorneys can work together to provide a more better estate planning for our clients is attorneys are knowledgeable about the legal aspects of estate planning. So they're knowledgeable about the law. They have good individual they're good individual counselors to clients. They're strong in finding the right legal paths to take. They're usually not as good in giving large seminars or marketing. They're not necessarily proficient in running the numbers. And to be successful, non-legal aspects of estate planning can be handled by others. So delegating. Some general strengths and weaknesses of financial advisors. So they're knowledgeable about financial aspects of estate planning. They are good individual counselors to clients on finances. They're strong in providing financial alternatives and scenarios in the estate planning process that attorneys usually, some may, but most attorneys aren't well adversed in. They're generally good in giving large seminars and marketing. Sometimes they're sale orientated, and they're proficient in running numbers. So the estate planning model, which I'm sure we're all pretty familiar with, but if you're not, attorneys work with advisors and advisors work with the attorneys, and then the estate planning source, is kind of our middle person go-to. They help us draft the documents. They help us connect with other advisors, attorneys, networking. So it kind of just funnels from the attorney to the client, from the client to advisors, and we all work together to come up with this best estate plan for that certain client. So the estate planning client education process. So just some bullet points here. Seminars and workshops, attorneys and financial advisors can hold them. General estate planning concepts. So not legal advice, just general estate planning concepts. Attorneys or financial advisors can give those. Specific estate planning counseling and advice, always defer that to the attorneys. General client information gathering, this can be done by the attorneys or the financial advisors. Specific estate planning client information gathering, I would err on the side of cautious and just have the attorney do that. And then financial information gathering, you can have attorneys or financial advisors do that, but usually the financial advisors are well versed in that, and you should have them do that. Some notes of caution for financial advisors is never advise a client on a legal course of action. Never state that this is what you should do. Abolish the mindset that you're selling estate planning documents. You're only assisting with general estate planning education. And never, ever hesitate to refer questions to the attorney. Always err on the side of caution, and just refer it to the attorney. Notes of caution for attorneys. Maintain the role as a primary advisor in the estate planning process. If you do work with a financial advisor, try and keep in mind that they help you with the process, but they do not lead it. You're the one that makes the legal decisions, and honestly going to be liable if something is wrong or comes back on you, So making sure everything's set up legally and functionality like that it's correct. So take the lead on it. Review all information received from the financial advisor with the client. Go over it, make sure their wishes are followed, etc. And then work closely with the financial advisor to streamline the process without sacrificing quality. Some benefits to the client with this approach is their financial plans and estate plans are coordinated. Potentially costs are lower because the attorney doesn't have to investigate finances and accounts as much, and general education provided to the client from the financial advisor through our seminars, our books, and other resources allows the attorney to focus on the purely legal aspect of estate planning. And obviously more than one professional maintaining contact on an ongoing basis. The process applied, this is just a general process. This doesn't have to be what you follow, what you do. This is just an example. So let's say a client attends a workshop or whatnot, and they go through the seminar. So the advisor can discuss general concepts of the trust without counseling of any kind. They can meet up with the client and provide the client with a workbook from the estate planning source. And then the advisor completes the detailed financial statement while the client fills out the estate planning workbook. Questions on filling out the workbook are directed to the attorney. Advisor sends workbooks to the attorney without any checks. Attorney discusses the case with the advisor and then the client. Always, as an attorney, have the client sign a retainer agreement. The attorney would send them the mini summary and terms of agreement for signature. When you receive the signed paperwork back, you as attorney would pay the estate planning source and then your advisor through that, and then you as attorney would handle the deeds as usual. Some more notes of caution for attorneys. Handle all aspects of the estate planning process except the detailed financial analysis, and in some jurisdictions, the execution of the documents. If you have to be there, then you have to do that, but some states you don't have to. Never allow the client to pay the advisor directly. Never allow the client to pay the estate planning source directly. Other non-legal functions can be assigned to the advisor. So benefits to clients. They still receive the best trust documents available. They have more than one professional maintaining contact and ongoing basis, and nowhere near the advisor crossing the line into the unauthorized practice of law. The process you should have is that all legal aspects are with the attorney. All money is paid directly to the attorney. The attorney submits the actual order to the estate planning source, and everything else is really negotiable between the advisor and the attorney to fit their needs in the process that they have in place. So, one hypothetical for you here. An advisor meets with a potential client. They're going over their workbook, filling in the blanks. Advisor has a strong opinion against appointing co-successor trustees. In the interim, client asks the advisor if they should appoint their son and daughter or just their oldest son as the successor trustee. Advisor informs client that they should appoint just their son, explaining in his opinion, when you appoint co-successor trustees, it can complicate things and make things take longer than they should. Is that the unlawful practice of law by the advisor? Yes. Never advise a client on a legal course of action. Always refer that to an attorney. You could maybe, as an advisor, word it differently and kind of give them examples and be like, if you did this, this would happen. This could happen. If you did this could happen. But never say, in my opinion, I think you should do this or that. It's just kind of on the border. It's just on the border of practice. The unlawful practice of law. Like I said, err on the side of caution, and any questions that are specific, defer to the attorney. In summary, the definition of what constitutes the practice of law is established by law and varies from one jurisdiction to another. Specific questions on what a client should do with their estate, giving advice about a client's legal rights, completing legal documents should always be deferred and handled by a licensed attorney. So if a client has specific questions regarding the estate plan and how it would function, how it would maybe affect their legal rights and the actual drafting of the documents, err on the side of caution and defer to the attorney. That is all I have for you. If there's any questions, I can take those now. Thank you guys for joining us today, and hope this information wasn't too boring and a little bit helpful.
Okay.
Are we all done?
Hello, everybody. I'm just kind of here for tech support, so greetings.
Greetings. Are we done, Shalene? No.
Yep, we are waiting for questions currently, if anybody has any.
Okay.
Jeff, do you want to go ahead and say yours? This is the one in the chat right now.
Sure. This is actually something that comes up quite often. If you go ahead, put together a plan for a married couple, you do the joint trust and all the documents, and then several years goes by. One of them clients calls back and says, hey, yeah, me and my husband or my wife, we're getting a divorce. And what I want you to do is cancel the trust and do my plan for me. How do you handle that for conflicts of interest?
So was the estate plan already completed or not yet?
Yes, it was completed, and now it's years later, they're coming back to you and there's going to be a divorce.
Oh gosh. I'd have to really dig into rule like duties to former clients. I don't have that book in front of me right now. Let me see if I can just look that up real quick. I feel like they're like if the wife came to you, like her interest would probably be adverse to what you had completed as a former client, as them jointly. You can always do the get like the exception. So like get the conflict of interest if you do think that there is one in that specific circumstance and have it waived, and just have see if you can get the other spouse to sign that. Let's see here. I would always say err on the side of cautious. I kind of feel like there could be a potential conflict of interest, depending on, like, if you're doing something adverse to the trust that you had set up. I think that there could be a conflict. If she were to come in and hire you once the divorce is finalized, and now the assets are split up and she wants you to create a new estate plan, I don't think that would be a conflict in my mind.
Okay. Yeah, this is actually something that I typically put into my engagement agreements, that I'm representing both of you. And I even specifically say, if you get to the point where there's a divorce, quote, only one of you can get me in the divorce and the other person has to sign off that that's okay. Otherwise, sure, I don't represent anybody.
Yeah, no, that's a good practice.
All right. Any other questions out there? Michael Alley Living Trust says, thank you, Jessica.
You're welcome.
We'll just give it another little moment, and then I think we'll say that's it. I did want to take the time to say thank you to everybody who's joined, and thank you, Jess, for speaking today.
You are welcome. Thank you, guys.
All right, I guess that'll be it for today. Thank you, everybody.